Today, we are going to be talking about the Oregon Revised Statutes and the Juvenile Code. The learning goal for today is to better understand foundational Oregon statutes and how they inform our work, to become familiar with O.R.S. handbook and Juvenile Code relevant to juvenile department work, and how to use the O.R.S. book, handbook, and O.R.S. online. What we're going to be talking about today is understanding may versus shall, and what that means when it shows up in O.R.S. We'll also be talking about Juvenile Code, including the general provisions surrounding Juvenile Code, which is 419A, Juvenile Code and Delinquency, which is Section 419C, and Criminal Code, Crimes and Punishments. We'll also talk about the Oregon Youth Authority Code and how to apply all the information in the statutes. The Juvenile Code 419 includes 419A, which is general provisions and definitions, 419B, which talks about dependency, 419C, which talks about delinquency, Chapter 420, which is about youth correctional facilities and youth care centers, and 420A, which is all about Oregon Youth Authority and youth corrections. We will attempt to organize the O.R.S. presentation in the order that a case travels through the juvenile system. So we will start off with 419C.225, which covers authorized diversion programs. Section 1 talks about following a review of a police report and other relevant information. A county juvenile department may refer a youth to the authorized diversion program if the youth is eligible to enter into a formal accountability agreement under O.R.S. 419C.230. This is a good example where it says may, so the juvenile department may refer a youth. It doesn't mean we have to. It's up to the juvenile department to determine if they want to allow a youth to enter into a diversion program. Section 2 talks about an authorized diversion program can include a youth court, mediation program, crime prevention, or chemical substance abuse education, or any other program that's established, and the purpose is for providing consequences and reformation and preventing future delinquency acts. There are many different diversion programs out there. Examples of this could be sole sanctions, peer court, a victim offender mediation program, and many others. Chapter 3 talks about an authorized diversion program for a youth who is alleged to have committed an act that is in violation of O.R.S. 813.010, which is driving under the influence of intoxicants. And if a juvenile department offers a DUII diversion program, it must include an agreement that the youth will not use intoxicants while the youth is participating in the diversion program. In Oregon, only a handful of counties run their own DUII diversion program through the juvenile court. Most of the other counties have a waiver that sends all DUIIs for juveniles to adult circuit court. 419C.230 talks about formal accountability agreements. In this section, we learn that a formal accountability agreement may be entered into when a youth has been referred to the county juvenile department, and a juvenile department counselor has probable cause to believe that the youth may be found within the jurisdiction of the juvenile court for one or more acts specified in 419C.005, which again talks about jurisdiction. So here again is the word may. So juvenile departments may enter into an FAA with a juvenile, but they don't have to. And the probable cause means that the juvenile department is allowed to review a police report and determine whether or not there is probable cause without a district attorney's oversight. Now, as we talked about before, in Oregon, there are 36 different ways of doing things. So some juvenile departments require that a DA look at this to determine probable cause. In other counties, the juvenile department alone determines whether or not a youth is referred for a formal accountability agreement. Chapter 419C, Juvenile Code Delinquency Continued. Formal accountability agreements continued. A juvenile department may not enter into a formal accountability agreement unless authorized by the district attorney's office when the youth is 1. Alleged to have committed a felony sex offense or an offense involving the use or possession of a firearm, or is being referred for a second or subsequent felony. So these are the times when may does not apply. These are shall. The juvenile department must consult with their district attorney's office if any of these three things are involved in the offense or referral. Formal accountability agreements continued in Chapter 419C.230. The juvenile department must consult the victim before entering into an agreement if the victim has requested consultation in plea negotiations and the alleged act constitute a violent felony. So again, this is not a may. The juvenile department must consult a victim if the victim has requested to be involved and there is a violent felony as part of the referral. In 419C.245 statute outlines that the youth has a right to a court-appointed attorney prior to entering into an FAA. And of course, the juvenile department counselors must inform in writing the youth of their right to counsel prior to entering an agreement. For most counties, while their forms may look a bit different, the 36 counties all have to do this the same way. 419C.239 continues with FAAs and the requirements of the agreement. When we talk about a formal accountability agreement, there are certain components that it has to have. An FAA shall be completed within a period of time not to exceed 1 year. The FAA must be voluntarily entered into by all parties. The parties include the youth, the juvenile department, and the family. The FAA shall be revocable by the youth at any time by a written revocation. So this is where, if the youth no longer wants to participate, they have to put it in writing. The FAA must be revocable by the juvenile department in the event the department has reasonable cause to believe the youth has failed to carry out any of the terms of the FAA or has committed a subsequent offense. The formal accountability agreement must not be used as evidence against the youth at any adjudicatory hearing. The FAA must be executed in writing and expressed in language understandable to the person involved, meaning the youth and the family. And the FAA must be signed by the juvenile department, the youth and the youth's parents or legal guardians, and the youth's attorney, if they have any, and the FAA must be part of the youth's juvenile department record. So these are all the shalls of the formal accountability agreements. 419C.005 Jurisdiction. The juvenile court has exclusive original jurisdiction in any case involving a person who is under 18 years of age and who has committed an act that is a violation or that, if done by an adult, would constitute a violation of a law or ordinance in the United States or a state, county, or city. So this is who falls under jurisdiction of the juvenile court and the juvenile system. It's basically anyone who is under 18 and who has committed an act that would be a violation or a criminal offense in any state, county, or city. 419C.091 Custody. Custody under 419C.080 and 419C.088, which is custody by a private person, shall not be deemed an arrest. So far as the youth is concerned, all peace officers shall keep a record of youths taken into custody and shall promptly notify the juvenile court or counselor of all youth taken into custody. What's important about this statute is to understand that the language in the Juvenile Code is different for that of adults. When juveniles are taken into custody by law enforcement or probation officers, it is not considered an arrest. It is only considered custody. 419C.085 Citation in lieu of custody. So law enforcement does not always have to take a youth into custody. They can issue them a citation instead of taking them into custody and bringing them into a juvenile department. In lieu of taking a youth into custody, a peace officer may issue a citation to a youth for the same offenses and under the same circumstances that a citation may be issued to an adult unless the citation is issued for a violation of law ordinance for which an order has been entered pursuant to 419C.370, which is a waiver of motor vehicles, boating, game violations, and property cases. The citation is returnable to the juvenile court of the county in which the citation is issued. In Oregon, we call these referrals. When law enforcement has contact with a young person in the community and they issue them a citation, they then forward the citation and their report to a juvenile department, and this is where we refer to it as a referral. Juvenile departments then enter it into JAGES and determine the next steps and how to proceed. Now we're going to switch it up and talk about probation and the statutes that govern probation. So what is probation? It's important to understand that probation is a judicial process, which means that it's granted and or revoked by a judge. O.R.S. guides that a judge will order probation when in the best interests of the welfare of the youth. Additionally, the court may order requirements during probation, including meeting with a juvenile counselor, and this can be found in 419C.446. Taking a closer look at 419C.446, probation, it outlines that when a court determines it would be in the best interest and welfare of an adjudicated youth, which means the youth has already been found guilty, the court may place the youth on probation. The court may also specify particular things that the youth must do and observe during the probation, consistent with recognized juvenile court practices. And this can include, but is not limited to, restricting visitation by the adjudicated youth's parents, restrictions on the adjudicated youth associates, where the youth can work, and which activities the youth can engage in or not, restrictions or requirements that must be observed by the youth or the adults having the youth's legal custody, requirements for visitation by and consultation with a juvenile counselor or any other suitable counselor. The court can require them to make restitution, to spend time in detention, to perform community service, and to submit to blood and buccal testing. There's also different and additional conditions for youth who have committed a sexual offense. And if you read further in this section of the statute 419C.470, it outlines that we as the juvenile department must create opportunities for the youth to fulfill these conditions. So whatever the court orders young people to do while they're on probation, we as the juvenile department and juvenile counselors must help them find opportunities in order to fulfill any of the conditions ordered by the court. Chapter 419C continued. Juvenile Code Delinquency. 419C.446 under probation requirements. It outlines that the court, the juvenile department, or any other agency may not order the adjudicated youth or the parents to pay any fee, cost, or surcharge as a condition of probation or to pay any probation supervision fee. Juvenile departments in Oregon used to require youth and families to pay supervision fees and or fines. Oregon changed this in 2021. Research shows that juvenile fees and fines perpetuate cycles of poverty and undermine the financial and emotional well-being of youth and their families. They disproportionately harm Black, Indigenous, Latinx, and low-income families and net little or no revenue for the government entities that assesses and collects them. Recognizing this, the Oregon legislature passed Senate Bill 817, which eliminated fines and fees in the juvenile legal system and required the discharge of all outstanding debt. O.R.S. 419C.450 regarding restitution. The victim has the right to receive prompt restitution. Juveniles are still required to make restitution to victims if ordered by the court or as part of their diversion. Chapter 419C continued. 419C.080 regarding custody. When youth may be taken into custody. If the youth were an adult, the youth could be arrested without a warrant. This is usually for a felony crime or other offenses found in the pre-adjudication statute. A youth can be taken into custody when the juvenile court has ordered that the youth be taken into custody. Additionally, when a youth is taken into custody in any order issued under subsection 1b of this section that may result in a substitute care placement or detention, the court shall include a written finding describing why it is in the best interest of the youth to be taken into custody. Chapter 419C continued. 419C.097 Notice to Parents and Victim. As soon as practical, after the youth is taken into custody, the district attorney or the juvenile department shall notify the parent, guardian, or other person responsible for the youth of the time and place of a custody hearing. Again, there's 36 different ways of doing this. In some departments, the juvenile department is who makes these notifications and files any paperwork, and in other counties, it's the DA's office. Subsection 2 talks about the victim requests such notification. The victim shall be notified of a time and place of the hearing. If there is a victim involved in this case, the Victim Assistance Office or whoever in your county works with the victim will notify them of the first hearing, will have them fill out paperwork, and if they indicate in the paperwork that they will want to be notified of certain hearings. A custody hearing is one that a victim can ask to be notified of. Continuing in 419C. 419C.130 A youth may not be detained with adults. A youth may not be detained at any time in a police station, jail, prison, or other place where adults are detained, except a youth can be detained at a police station for up to 5 hours when needed to obtain the youth's name, age, residence, and any other identifying information. This is why our detention facilities are separate and why young people cannot sit in adult facilities or police stations where other adults may be, unless we need to find out who they are and figure out other identifying information. They are not to have sight or sound with adults. 419C.133 Detention Review of Youth Under 12 Years of Age. In Oregon, youth are not allowed to be put in detention if they are under 12 years of age. The only time that they can is if there is a judicial review and written findings. So youth have to be 12 years or older to be placed in detention. And if they are under 12 years of age and someone is seeking to have them be placed in detention, they must go before a judge and have the judge make written findings, ordering them to be placed in detention. Again, how courts do this in 36 different counties may vary, but that is a requirement. There must be judicial review and written findings before it can happen. 419C continued. 419C.142 Notice of Detention Hearings. Once a youth is in custody, a notice of a detention hearing shall be given to the youth, the parent or guardian, or any other person responsible for the youth, and the victim, if requested. And this section also outlines that the notice given to the youth, the parents, and the victim shall state the date, the time, the place, and purpose of the hearing. If the parent or guardian or the other person cannot be found and personally notified prior to the hearing, a written notice of the hearing shall be left at the residence, if known, of a parent or guardian or other person. So again, this is a shall. It is not if we want to give them a notice or not. We are required to give them notice. And if we cannot find them, we have to leave a notice at their residence. We will now move into talking about detention. First, pre-adjudication detention 419C.145 outlines when a youth may be held or placed in detention before adjudication. It will occur if one of the following exists: if the youth is a fugitive from another jurisdiction, if the youth is alleged to have committed a crime involving affliction of physical injury to another person, or if they are alleged to have committed first-degree disorderly conduct or a felony crime. Again, notice the pre-adjudication detention statute says may. Thus, these are decisions that each county juvenile department makes regarding when they detain a youth for any of these reasons, and we'll talk more about this a little bit later. But some facilities use a detention risk assessment tool, and that's how they make their decisions whether or not to detain. Some counties may detain and place a youth in detention that has a detainable offense under the statute. Best practices state that we should only detain youth if there is a risk to absconding or a public safety concern. 419C.145, continuing with pre-adjudication detention. A youth can also be held in detention if they willfully fail to appear at one or more court hearings, which usually, if they fail to appear, the court will issue a warrant. A youth may be detained pre-adjudication if there is probable cause to believe the youth has violated a condition of probation. Again, this is may. If a youth has violated a condition of probation, we may, if we have probable cause, detain them. A youth may be detained if there is probable cause to believe that the youth has violated a condition of release. Chapter 419C.145, Pre-adjudication detention continued. A youth may also be detained in detention if the youth is alleged to unlawfully in possession of a firearm, or for the reasonable protection of the victim. Thus, if a youth has a crime regarding unlawful possession of a firearm, they can be held in detention. And if there is a victim that is not safe, if the youth is not detained, for reasonable protection of that victim, the youth may be detained. Continuing with pre-adjudication detention in 419C.145, at least one of the following circumstances must also be present when placing a youth in detention. First, there are no means less restrictive available to assure that the youth will attend the adjudicatory hearing, which means that there is no least restrictive placement the youth can go that will guarantee that they show up for their next hearing. Second, the youth's behavior endangers the physical welfare of the youth, the victim, or another person in the community. There must be a risk to public safety when we use detention pre-adjudication. This is important to keep in mind when making detention decisions, and is somewhat the foundation of what our decisions should be made upon, whether or not the youth will show up for court hearings in the future, and whether or not there is risk of continued harm. This is where using a detention risk assessment comes in. Detention risk assessments help us determine the likelihood that the youth will abscond or fail to appear for a next hearing, and whether or not there is a public safety concern. Again, there are 36 different counties, and everybody determines how they make these decisions around detention in their own county. If we want to be making equitable decisions, a detention risk assessment helps the consistent decision making, and we know that consistency is the foundation of equity. 419C.139, Speedy Hearings on Detention Cases. So once a youth is placed in detention, there are some statutes that guide how fast we need to act to have the matter resolved. No youth shall be held in detention for more than 36 hours excluding Saturdays, Sundays, and judicial holidays without a hearing and a court order to remain in detention. So once we admit someone into the detention facility, we then, within 36 hours, excluding weekends and holidays, need to have a hearing before the juvenile court, and the court must order that they remain in detention if they are to stay. The Oregon Juvenile Detention Facility Guidelines. In Oregon, we do have a requirement that detention facility guidelines be available and updated regularly. This document is put out by Youth Development Oregon, YDO. The guidelines are a compilation of statutory and federal requirements as well as best practices. In the 2020 guidelines regarding detention facilities, Section 2.1 discusses intake decisions and outlines that each county shall designate an organizational unit that is available 24 hours a day with responsibility for the intake decision process that is delegated the specific power to make decisions regarding intake into a detention facility. When making the decisions, the following principles will be used to make determinations, and this will be based on best practices. The three principles are objectivity, uniformity, and risk-based. The 2020 version of the Juvenile Detention Facility Guidelines can be found online on the Youth Development Oregon's webpage. Objectivity refers to making decisions that are based on racially bias-free, neutral, and objective factors, such as outlined in O.R.S. 419C.145. Objective criteria anchor detention decisions in ascertainable facts, such as the nature and severity of the offense, the number of prior referrals, or the minor's history of flight from custody. Uniformity. Local criteria should be uniform in the sense that they are applied equally to all juveniles who come into detention. To achieve the desired level of uniformity, the criteria must be a written or electronic format and must be incorporated into a screening process that is standardized for all referrals. And risk-based. The criteria should be risk-based, meaning that they should measure specific detention-related risks posed by the juvenile. These risks are the risk of reoffending before adjudication and the risk of failing to appear at a court hearing. For facilities that use a detention risk assessment, all three of these objectives are built within the decision-making by a risk assessment. Risk assessments help to ensure that the decision is made based on the objective criteria, that is uniform across all youth, that is based on risk, and using this criterion for detention and admission decisions increases equity across gender and race. Look for the Detention Risk Assessment Guidelines to be renewed in 2025. Chapter 419C.153 Detention Review or Release Hearing. Once a youth has been placed in detention, a youth shall have a review hearing every 10 judicial days, which excludes Saturdays, Sundays, and judicial holidays. If requested, the District Attorney's Office or the Juvenile Department shall notify the victim of the detention review hearing. After that very first detention hearing, if the court remands a youth into detention after that, there must be a hearing every 10 days, excluding weekends and holidays. And notice this is a shall, not a may. This is very different than the adult system. In the adult system, they can sometimes go months or longer without a review hearing, but juveniles have to have one every 10 days. Chapter 419C.156 Detention of Runaway from Another State. Another way that a youth can be placed in detention per statute is if the youth is an out-of-state runaway. The court may place the out-of-state runaway in a placement that the court determines to be the least restrictive setting, including detention, necessary to ensure that the out-of-state runaway is not a danger to self or to others pending the return of the out-of-state runaway's home state. Nothing in O.R.S. Chapter 419A, 419B, or 419C limits or affects the ability of a court to place an out-of-state runaway in detention in accordance with Interstate Compact for Juveniles, which is outlined in O.R.S. 417.030. The out-of-state runaways are sometimes tricky for counties because of the cost of detention. When the state where the youth has ran away from is unable to come and get the youth, or the parents or family are unable to get them, these youth sometimes end up in detention for many weeks, and that costs money. Interstate Compact on Juveniles does outline some guidance around figuring out who pays for the cost of detention, but for the most part, there's nothing completely enforceable, and the detention facility that is holding the out-of-state runaway usually ends up covering the cost. Chapter 419C.150 Time Limitations in Detention. A youth may be held in detention for a maximum of 28 days. If good cause is shown, detention may be extended for no more than an additional 28 days, unless with the express consent of the youth. This statute helps to ensure that the youth are not held in detention for long periods of time while the case drags on. If the court finds good cause to go beyond 28 days, the youth must agree to go beyond the 56 days. These are calendar days, not judicial days, and this statute does not apply if a youth is alleged to be within the jurisdiction of a juvenile court for having committed an act that would be murder, attempted murder, conspiracy to commit murder, or treason if committed by an adult. And if proof of the act is evident or the presumption is strong that the youth committed the act, the juvenile court may conduct such a hearing as the court considers necessary to determine whether the proof is evident or the presumption is strong. Crimes and punishments. These are different chapters of the Oregon Revised Statutes that speak to different crimes and their punishments. Chapter 161 talks about general provisions, explaining some terms, and disposition of youth. This area also discusses offenses against the state and public justice, such as false swearing, escape, obstructing justice. 163 Offenses against persons. These are person crimes: assault, homicide, sexual offenses, stalking, etc. 164 is property crimes such as theft, burglary, robbery, arson, and criminal mischief. 165 are offenses involving fraud or deception, forgery, identity theft, fraudulent use of a credit card, etc. Chapter 166. This discusses offenses against public order, firearms and other weapons, and racketeering. It includes disorderly conduct, riot, weapons, and firearms. 167. Offenses regarding general welfare and animals. It includes prostitution and tampering with drug records. And 169. Local and regional correctional facilities, prisoners, and juvenile facilities. This discusses the requirements for facilities such as procedures, compliance to standards, and treatment of detainees. 419C continued. Some of the sections in this chapter are 419C.349 Grounds for Waiving Youth to Adult Court. In 2019, Oregon passed Senate Bill 1008, which significantly altered how juvenile sentencing for serious crimes was handled, effectively repealing the harsh provisions of Measure 11 for youth. Specifically, this bill ended the automatic waiver of 15 through 17-year-olds into adult court for Measure 11 crimes. Waiving youth to adult court under 419C.349 is now the only way that a youth can be waived to adult court for an A or B felony and only certain C felonies. 419C.352 Grounds for waiving youth under 15 years of age. A youth under the age of 15 can be waived to adult court if requirements in 419C.349 are met and the youth is alleged to have committed one of these following acts: murder or any aggravated form, rape in the first degree, sodomy in the first degree, or unlawful sexual penetration in the first degree. 419C.370 Waiver of motor vehicle, boating, game violation, and property cases. This is a statute that most counties use and have a blanket waiver for all motor vehicle referrals, including DUII charges, to be waived to a traffic court, which is usually handled in circuit court. How does your county handle traffic crimes and violations for juveniles? Chapter 419C.453 Detention when authorized. This section is talking about how detention can be used for adjudicated youth. Detention can be ordered as a disposition for an adjudicated youth. The court may place the youth in detention as part of that disposition. It is not to exceed 8 days per petition in addition to time already spent in detention on the petition. Thus, if a youth was in detention while their case was pending and then they were adjudicated, as part of that sentence, they were sentenced to 8 more days, they could serve that, in addition to the time they'd already spent in detention. And detention is authorized at a maximum of 30 days if in a facility that conforms to Youth Development Oregon standards. Several counties have a 30-day program in their detention facility, and the youth may be ordered to complete a 30-day detention program as part of all their disposition. All of the 30-day programs have to be approved by Youth Development Oregon. Chapter 419C, the Juvenile Code Delinquency Continued. This includes 419C.462. Appropriate community service may be ordered as a condition, and community service limitations of hours per offense is in 137.129. 419C.465 discusses services to victims. A youth can be ordered to perform personal service for the victim as a condition of probation. However, there are some conditions and limitations to this. 419C.472 Oregon Driver's License Suspension. This discusses when the court may apply this, such as for certain alcohol and marijuana offenses, and if the youth fails to appear. 419C.473 Blood and buccal samples. For some cases, youth are ordered to give these samples. This is usually when there is a person-to-person crime and the victim could be at risk. 419C.475 bloodborne infection testing. Again, similarly, this is based on the nature of the offense and the risk to the victim.
Let's talk about parole. What is parole? Parole is an administrative process which means it's granted and or revoked by the administrator of the Oregon Youth Authority or their designee. Parole is a conditional release from incarceration. See the sample parole agreement, which can be found on OIA's website. Once a youth has been committed to a youth correctional facility, when they are allowed to get out of the facility, they are released on parole. Parole follows a process outlined by Oregon administrative rules and case law. 419C continued the Juvenile Code delinquency. This is regarding the Oregon Youth Authority. 419C.478 commitment to OIA or DHS, and what that involves and when and how a youth can be committed. They must be 12 years of age to be committed to OIA. A court may commit a youth to OIA for a community placement or a youth correctional facility, in addition to probation or any other disposition. The court shall include written findings describing why it is in the best interest of the adjudicated youth to be placed with the youth authority. 419C.495. When committed to a youth correctional facility is authorized. A youth may not be retained in a youth correctional facility after the youth has attained 25 years of age. If a youth is sentenced to the amount of time that would go past their 25th birthday, they must be paroled. If a youth is waived to adult court and sentenced as an adult, they serve their time at YCF until age 25, at which time they can no longer be in a youth correctional facility, so they can be transferred to an adult prison to serve out the remaining of their time on their adult sentence if they are not yet eligible for parole. Chapter 420, Oregon Youth Authority. 420.011 Admissions to Youth Correctional Facilities. Subsection 4. A youth must be age 12 but less than 20 years of age at the time of admission, or over 15 years old but less than 20 years if for a crime found in 137.707, mandatory minimum sentences for certain juveniles waived to adult court. This is the age span when a youth can be committed to a youth correctional facility. The youth must be 12 years or older but under the age of 20 at the time they admitted to their offense. Youth committed to the YCF must be committed on aggravated murder, a felony, or a Class A misdemeanor. These are the crimes that have to be present for a youth to be committed to the correctional facility. If they have a B misdemeanor or a C misdemeanor, they are not eligible to be committed to a YCF. And each of these offenses carry a maximum amount of time that they can be committed to a youth correctional facility. For example, most felonies are anywhere from 5 to 20 years, whereas a Class A misdemeanor is a maximum of 12 months. Under 137.707, there are mandatory minimum sentences for certain juvenile offenders that have to be waived to the adult court. These sentences do not apply to youth under age 15. Chapter 419C, the Juvenile Code, Delinquency Continued. 419C.501, Duration of Disposition. These are the same timelines as for adults for each type of offense, such as 30 days for C misdemeanors, 12 months for an A misdemeanor. Concurrent versus consecutive. What does that mean? Concurrent means at the same time. Consecutively means one after the other. In Oregon, juvenile courts generally do not have the authority to impose consecutive commitments unless specifically authorized by statute. The Oregon Court of Appeals has held that the Juvenile Code does not explicitly permit the imposition of consecutive commitments. The Court of Appeals case made the argument that when youth have multiple offenses for which they've been adjudicated, courts were giving dispositions that would stack them one after the other, and they argued that there was no authority to do so. So let's say a youth has 3 A misdemeanors. We know a youth can only be committed to OIA for 1 year for each A misdemeanor. But if a youth were adjudicated for 3 A misdemeanors, some courts were making them consecutive. So the youth would serve 3 years in OIA custody because they had 3 A misdemeanors. What this case law argued was that it was not fair and they should be served concurrently. So even if a youth had 3 A misdemeanors, youth would serve them all at the same time. So a youth would still only serve 1 year in OIA because the youth would serve each of those sentences, A misdemeanors, at the same time. However, the Oregon Supreme Court has reversed the Court of Appeals on this issue, stating that the statutory text neither expressly permits nor prohibits consecutive commitments. Thus, it remains up to each individual court to determine if commitments should be concurrent or consecutive. 419C.504 Duration of probation. When a youth is placed on probation, that probation cannot exceed 5 years and it cannot extend beyond the youth's 23rd birthday. This is one that not all counties are familiar with. So think to yourself, how long do you have youth on supervision in your county? Is it indefinite? Is it 2 or 5 years? Or do you have termination of probation dates? Do you have jurisdiction end dates? It's always good to make sure that probation is not exceeding past 5 years for any juvenile case. And yes, that does mean if youth turned 18 by the time they were adjudicated and they were placed on probation for 5 years, you could be supervising a youth who is 22 or 23. .419C Juvenile Code Delinquency Continued. Authority of courts over parent or guardian. 419C.570 Subsection 1. In all cases in which an adjudicated youth is placed on probation, the juvenile department and the parent or guardian shall develop a plan for supervision of the adjudicated youth. The court shall review and ratify the plan and make the plan a part of the probation order. The statute outlines how a court has the authority over the parent or guardian. Now again, what does a plan for supervision look like? There's probably 36 different versions out there for all 36 counties. And there are plenty of counties that don't do a plan, even though the statute says shall. Do you do any kind of plan for supervision that you engage the youth and family in, and they help create? There are many counties that use a case plan, and that can be considered a plan for supervision that would meet the statutory requirements. Chapter 419C, Juvenile Code Delinquency Continued. Authority of court over parents or guardians. 419C.573, Subsection 1A. The court may order the parents or guardians to participate in any educational or counseling programs as are reasonably directed towards improvement of parenting skills. This statute allows the courts to actually make orders of the parents to do certain things if it is needed for the youth to be successful. Think to yourself whether or not your county has ever ordered parents or guardians to do something in a juvenile case. 419C.575. The court may conduct a special hearing to determine if the court should order the parent or guardian to participate in drug or alcohol treatment. If there is a substance abuse issue going on, and usually the court looks at whether or not the substance use is impacting the youth in a detrimental way, the court does have the authority to order a parent or guardian to engage in drug and alcohol treatment. This is just an overview and highlights of O.R.S. and the Juvenile Code. One of the best ways of getting familiar with the Juvenile Code is to look up different sections, whether that's in your Oregon Revised Statute book or using the O.R.S. online. If you have an O.R.S. statute book, it is helpful to place tabs to mark these sections that are most relevant to your work in the juvenile justice system. The online version of Oregon Revised Statute is very handy, very easy to look up statutes. If you're looking up what does O.R.S. say about certain topics, the search feature is very good. And the way that the O.R.S. looks online is very easy to see what you need. If you are going to court, this is where having your O.R.S. book with its tab markers is very helpful, and may be the only way you can look things up when you're in the courtroom, because you may not have access to a computer. In some counties, they order their staff the Pocket Guide, which is a small pocket-sized handbook, and you can get one just of the juvenile codes to carry with you in the field if needed to look at something quickly.
All of the links to these resources can be found at the end of this presentation.
Thank you so much for learning more about Oregon Revised Statutes and the Juvenile Code. This training is brought to you by the Oregon Juvenile Department Directors Association, OJDDA, and the OJDDA Training Committee. Resources and quiz. Here are the links to resources cited or referenced in the training materials. Please click the link to take the O.R.S quiz.